You know, if you're trying to find the absolute gatekeepers of meritocracy in state governance, the people who ensure that administration is competent and impartial, you're looking right at the state public service commissions, the SPSCs.
Exactly. And they aren't some kind of historical relic. They are, and I mean this, the absolute bedrock that good governance is built on.
We're talking about the whole constitutional architecture behind them, everything from appointments to removals, and then how that connects to the All India services, to judicial review, even social justice.
And that's the key. We're giving you the ultimate shortcut today. This isn't just reading the blueprint. We're getting into the real engineering of public administration itself.
Welcome back to the deep dive. Now, before we really jump into the core material, we have a quick but really vital request. If this level of detail and analysis is helping you, please take a moment to support us.
It makes all the difference.
Humbly, we're asking you to subscribe to our YouTube channel, Simplified UPSC by PTP. And, you know, if you're in a position to, please think about joining our paid membership.
That support, especially from our members, is the engine. It's what lets us put in the time and resources to build these really useful deep dives. So a massive heartfelt shout out to all of our existing members.
Your support is absolutely crucial. Thank you for making this possible. And as you're listening, please just hit that like button and maybe share a comment below. It really helps other people find this material.
And just quickly on the resources, we've got free notes covering everything we discussed today, plus practice PYQs. They're available right now on our Telegram channel.
And for those of you who want to go even deeper,
Premium notes. They include extra PYQs and detailed model mains answers, and they are waiting for you on our Discord channel. That's an exclusive for our Legend YouTube members, so do join there if you can.
Okay, let's get into it. Our mission is clear. A full deep dive into Chapter 45 of M. Laxmikanth's 8th edition, focusing on the state public service commissions. But we're not stopping there.
No, we're immediately connecting that foundation to the bigger constitutional picture. We're talking all India services, fundamental rights, judicial principles, and then linking it all to the kind of real-world policy questions that the UPSC demands you master.
We'll synthesize the core articles and functions, then broaden out to analyze those key UPSC concepts, and we'll spend a good amount of time dissecting past mains questions.
So you can see how governance failure connects to, say, a security crisis or an economic policy. It's all connected.
All right, let's start at the very beginning, the constitutional mandate for the SPSC.
We begin with the foundation. And what's really fascinating here is how the Constitution itself secures the existence of these institutions. It insulates them from, purely political whims at the state level.
And that all starts with Article 315, right?
It does. Article 315 is the framework. It mandates a public service commission for the union, that's the UPSC, and critically, a public service commission for each state.
So that ensures a baseline, a standard across the country, no matter what political party is in power.
Precisely. The administrative machinery has to be based on a merit-based system. But Article 315 is also quite flexible. It accounts for something called a State Public Service Commission, or JSPSC.
A JSPSC. So that's for when two or more states decide to share a commission.
Exactly. It's a provision for cooperative federalism. Two or more states can agree that it's more efficient to have just one public service commission serving all of them.
But how does that get set up? It can't just be an informal agreement between two chief ministers, can it?
Absolutely not. And that's the key. The Constitution is very clear. The JSPSC is established only after a request from the concerned state legislatures. So the state assemblies have to pass a resolution first.
And then?
Then it requires an act of parliament to actually create it. So the center facilitates, but it cannot impose it. It really shows how sensitive the framers were to state autonomy.
Okay, so that's the structure. What about the people? Let's get into Article 316. Appointment and term of office. How are they protected?
All right, Article 316 specifies that the governor of that state, their term is fixed 6 years or until they turn 62, whichever comes first. That fixed tenure is the first layer of security.
But the real independence comes from what happens after their term, doesn't it?
It does. And that brings us to Article 319, which is all about the post-retirement restrictions. The whole point is to remove any incentive for a member to, try and win favors with the government for a future job.
So it's about preventing political co-option.
100%. Article 319 is very strict. It explicitly says that the chairman or a member of an SPSC is not eligible for reappointment to that same office after their first term. No second term.
So one and done in that specific role. But can they move to a different commission? Like, can a member of a state PSC be appointed to the UPSC?
Yes, and that's the nuance. A chairman of an SPSC can be appointed as the chairman or a member of the UPSC or as the chairman of another SPSC.
And a regular member.
A regular member of an SPSC can be appointed as the chairman of that same SPSC or any other SPSC, or as a member or chairman of the UPSC.
Okay, so the restriction is very specific. It's about preventing the executive from just offering extensions in the same job to keep someone friendly.
That's the core of it. It maintains independence but still allows the system to use that expertise at a higher level.
Now, this is a body designed to be independent, a check on the executive. Which brings up the big question covered in Article 317. How do you remove them? If the governor appoints them, does the governor fire them?
And this is where their security of tenure is really cemented. The governor appoints, but the governor absolutely does not remove.
So who does?
The president. The removal process is designed to be very difficult. Article 317 is clear. The removal of any Public Service Commission member, whether SPSC or UPSC, has to be done by the President of India.
And only on specific grounds, I assume?
Correct. Only on grounds of proved misbehavior or incapacity. And here's the crucial step. In cases of alleged misbehavior, the matter must be referred to the Supreme Court for an inquiry.
And the Supreme Court's advice.
It's binding on the president. So this whole complex procedure, presidential action based on a mandatory Supreme Court investigation, is the highest guarantee of their independence. It shields them from the state executive.
So Article 317 is their ultimate shield. What about suspension, though, while an inquiry is going on?
Good question. While the final decision is pending, the governor of the state does have the power to suspend the member. But that's a temporary measure. It's not the same as the power of permanent removal.
Right. And what about the nuts and bolts? Salaries, staff, resources? Who controls that?
That falls under Article 318. It gives the governor the power to make regulations about the conditions of service for the members and staff, and also the number of members on the commission.
So the executive controls the purse strings and the staffing levels.
It does. And that creates a bit of a subtle tension. The executive controls the resources, but the SPSC has to remain functionally independent in its decisions.
Okay, let's shift from the structure to what they actually do. We always think about recruitment, but you mentioned a dual mandate.
We do. The first role is the obvious one. The SPSC conducts examinations for appointments to the services of the state. That's their direct executive function. But the second role, the one people often underestimate, is their role as a central consultative and advisory body to the government.
And what does that consultation cover? It's more than just hiring, right?
Oh, much more. It covers almost every major part of personnel management. The methods of recruitment, the principles for promotions and transfers, and, very importantly, they advise on all disciplinary matters affecting civil servants.
So they're ensuring fairness and consistency even after someone is in the job.
Precisely. They also advise on things like claims for legal costs if a civil servant gets sued for something they did in their official duties. This broad advisory role stops the government from making arbitrary, politically motivated decisions about its own workforce.
And you can see how that connects directly to the idea of a welfare state.
Absolutely. Think about it. To run massive welfare schemes, you need a professional, impartial administration. If the government could just hire, fire, and promote based on politics, the whole system would collapse into a tool for partisan gain, not public service. The SPSC is what keeps that administrative backbone strong.
Okay, so we've established the SPSC as the guardian of state-level meritocracy, but the administrative machinery is bigger than that. Let's talk about the All India Services, the AIS. They're that crucial federal bridge.
They are. The AIS is a very unique feature of Indian federalism. Right now you have the Indian Administrative Service, IAS, the Indian Police Service, IPS, and the Indian Forest Service, IFAS, which was added in '66. They really embody that constitutional preference for a strong center.
And their defining feature is this idea of dual control. How does that actually work in practice?
So AIS members are recruited and trained by the center, but they spend most of their careers working in state cadres. The immediate day-to-day control, their posting, their leave, that's with the state government.
But the ultimate control.
The ultimate control over things like recruitment, training, and major disciplinary actions, that rests firmly with the central government.
So there's always a central leverage, even if a state government wants to go in a completely different direction.
That's the whole idea. It's designed to ensure uniform application of national policy and to protect officers from overwhelming regional political pressure. Of course, the tension is that states sometimes feel it undermines their autonomy.
And what if we wanted to create a new All India service? What's the process for that? That's Article 312, and it's a great example of a federal check.
It is. Article 312 says Parliament can create a new All India service. But, and this is a huge but, it can only do so if the Rajya Sabha, the Council of States, first passes a resolution asking for it.
And not just a simple majority, right?
No, it has to be a special majority. 2/3 of the members present and voting.
So why the special power for the Rajya Sabha? Why not the Lok Sabha?
Because the Rajya Sabha represents the states. Since a new AIS directly affects the administration and finances of the states, the Constitution demands the explicit consent of the body that represents those states. It's a powerful safeguard against the center just imposing its will.
Makes sense. Now let's move from the services to the individuals within them. The safeguards for civil servants under Article 311, this feels fundamental.
Oh, it's absolutely fundamental. Article 311 provides two main constitutional safeguards, and they are cornerstones of administrative justice.
What's the first one?
The first is that no officer can be dismissed, removed, or reduced in rank by an authority that is subordinate to the one that appointed them.
So basically, your boss's boss has to be the one to take serious action against you. It prevents capricious action from a junior official.
Exactly. And the second safeguard is probably the most famous part of Article 311. It's the right to defend yourself.
The reasonable opportunity.
The reasonable opportunity. Generally, no punitive action can be taken without holding proper inquiry and giving the person a chance to hear the charges and defend themselves. It's the principle of natural justice written right into the Constitution.
But there are exceptions, and these are critical to know. 3 situations where the government can bypass this inquiry.
Right. And these exceptions are where things get contentious. First, if the person has been convicted on a criminal charge, the facts are already established by a court, so a departmental inquiry isn't needed.
Okay, that one's logical. What's the second?
The second is impracticability. If the authority empowered to dismiss the person is satisfied and records in writing the reasons why it's not reasonably practicable to hold an inquiry.
That sounds open to misuse.
It can be, but there are 2 checks. First, the reasons have to be in writing, which means the decision can be challenged in court as being arbitrary. Second, the burden is on the government to prove to the court that it really was impracticable. Say, witnesses were being threatened.
Okay, and the third exception?
Security of the state. This is the highest level. If the president or the governor is satisfied that it's not expedient in the interest of state security to hold an inquiry, this is for extreme cases, like espionage or something similar.
So the Constitution tries to strike a balance. It protects the bureaucrat, but still gives the executive power to act decisively when absolutely necessary.
That's the balancing act, precisely.
All right, now let's pull the lens back and connect this administrative state to the bigger picture of rights and judicial power. We have to start with the Supreme Court, the sentinel on the qui-vive.
And the first thing to note about India's judiciary, especially if you compare it to a place like the USA, is that it's an integrated system.
Meaning one single hierarchy of courts.
Exactly. One system from the local courts all the way up to the Supreme Court, and it enforces both central and state laws. This ensures legal uniformity across the country, which is vital for these administrative services to function smoothly.
And the main tool the court uses to enforce that uniformity is judicial review. The basis for that being Article 13.
Article 13 is the bedrock of judicial review when it comes to fundamental rights. It says very clearly that the state can't make any law that takes away or abridges your fundamental rights. If it does, that law is void.
Which gives rise to this idea of the doctrine of severability. The court doesn't have to throw out the entire law.
Right. They can just sever or cut out the one part that's unconstitutional and let the rest of the law stand. It's a way of fixing the problem without causing massive legislative chaos.
And the ultimate tool for a citizen to protect their rights is the writ jurisdiction. This is a classic UPSC topic. The difference between Article 32 for the Supreme Court and Article 226 for the high courts.
It is, and the distinction is about both scope and obligation. A remedy under Article 32 is itself a fundamental right. It's your right to go to the Supreme Court.
Yeah.
Because of that, the SC generally cannot refuse to hear a case if a fundamental right has been violated.
So it's mandatory for the Supreme Court. But for the high courts, under 226, it's discretionary.
Yes, it's discretionary for high courts. But, and this is the critical point, the scope of Article 226 is much wider.
Wider how?
While Article 32 is only for the enforcement of fundamental rights, Article 226 covers fundamental rights and any other purpose.
And that phrase, any other purpose, what does that actually cover?
It covers your ordinary legal rights, rights that come from a statute or common law, but aren't in the Constitution as a fundamental right. So a dispute about an administrative action, a contract with the state, things that might violate a law but not necessarily a fundamental right.
So the High Court is often the first stop for most administrative law challenges.
In many cases, yes, this wider scope makes it incredibly powerful.
Let's talk about the evolution of one of those rights. Article 21, the right to life and personal liberty. It's amazing how the Supreme Court has expanded the meaning of life.
It's a perfect example of judicial activism. The best way to understand it is to compare the early, narrow view with the modern, expansive one. In the A.K. Gopalan case in 1950, the court took a very literal view. It said procedure established by law was just that, a procedure. As long as the government followed the letter of the law, it was fine, even if the law itself was unfair.
Which is a very limited protection.
Extremely limited. But that was completely overturned in the landmark Maneka Gandhi case in 1978. The court did a complete 180.
And what did they say then?
They said the procedure itself must be fair, just, and reasonable. This basically brought the spirit of due process into Article 21. Now, any procedure that's arbitrary or unfair can be struck down even if it's passed by Parliament.
And that opened the floodgates for a whole host of new rights under Article 21.
It did. The list is huge now. The right to livelihood, privacy, health, shelter, a decent environment, and very relevant to our discussion, the protection against hazardous industries.
Which means the decisions made by the civil service, recruited by the SPSC, can now be measured against this much higher constitutional standard.
Absolutely. Their actions have direct constitutional implications.
Yeah. Okay, moving to social justice. Article 16, equality in public employment. The landmark case here is obviously the Indra case, the Mandel case.
The Indra case in 1992 was a watershed moment. The Supreme Court upheld the 27% reservation for other backward classes, or OBCs. It affirmed the idea of compensatory discrimination. But it also introduced a massive condition.
The exclusion of the creamy layer.
The exclusion of the creamy layer. The court said that those within the OBC category who are already educationally and economically advanced shouldn't get the benefit of reservation.
And what was the logic behind that?
The logic was that if you didn't exclude them, the benefits would just be cornered by the most privileged among the backward classes, and the policy would never reach the people who truly needed it. It was about ensuring equality within the backward classes themselves.
And more recently, we have the 103rd Amendment from 2019, bringing in the EWS reservation.
Right. This brought in a 10% reservation for economically weaker sections, both in jobs under Article 16 and education under Article 15. This was a big shift because it made economic disadvantage a standalone reason for reservation, separate from social backwardness.
And it's only for those not already covered by SC, ST, or OBC quotas.
Correct. It's a separate category.
Finally, let's tie this to the ultimate test of the system, emergency provisions. This is where you see how fast India can pivot to a unitary state. Let's focus on national emergency under Article 352.
The emergency provisions really changed the entire structure of governance. A key thing to remember is that the process for approval was made much stricter by the 44th Amendment in 1978 after the excesses of the 75 emergency.
So what are the rules now?
A proclamation of national emergency has to be approved by both houses of Parliament within 1 month, and it has to be by a special majority. If it's approved, it lasts for 6 months and can be extended, but it needs that same special majority approval every 6 months.
And what about the suspension of fundamental rights? This is where Article 358 and 359 come in.
Right. Article 358 deals only with the 6 freedoms under Article 19, speech, assembly, and so on. These are automatically suspended, but only if the emergency is because of war or external aggression, not if it's for armed rebellion.
Okay, so Article 358 is automatic but limited. What about 359?
Article 359 is different. It allows the president to issue an order suspending the enforcement of other fundamental rights. But the 44th Amendment added a non-negotiable absolute firewall.
Articles 20 and 21?
Articles 20 and 21. Protection against conviction for offenses and the right to life and personal liberty. These two can never, under any circumstances, be suspended. That change cemented the idea that even in a national crisis, life and liberty are sacrosanct.
All right, knowing the articles is one thing, but the UPSC demands synthesis. Let's connect this to the real world using some previous year questions from our source material. This is where we really see how all these pieces fit together.
This is the application part. You have to be able to link an administrative failure directly to, say, a security threat.
Okay, let's start there. Governance and security. there's a question analyzing the impact of the non-implementation of the fifth schedule on the growth of left-wing extremism.
This is a classic example. The fifth schedule in Article 244 are all about administering tribal areas and protecting tribal rights, especially regarding land and resources. When the state administration, staffed by the officers we've been talking about, fails to implement these protections, it creates a massive governance vacuum.
And what does that failure look like on the ground?
It looks like tribal land being illegally taken over by outsiders or industries. It looks like moneylenders exploiting them. When the state fails to protect their fundamental connection to their land and forests, it creates this deep sense of injustice and displacement.
And that's the vacuum that extremist groups fill.
That's exactly it. They step in and offer their own form of justice and resource control. So you can draw a direct line from the failure of a district administrator to enforce the fifth schedule to a major internal security crisis.
Sticking with security, let's talk about border management, the link between India's internal security and its long, porous borders.
Porous borders are a huge challenge. They create pathways for all sorts of threats. You have the movement of non-state actors like militants. You have illegal migration, which can cause social friction. And you have rampant smuggling of drugs, weapons, counterfeit currency.
Which provides the money for these internal threats.
Exactly. And managing that requires not just good police and paramilitary forces, but also very capable civil administrators in those border areas to handle the socioeconomic pressures. Again, it comes back to the quality of the administration.
Let's shift to economic and social policy, the link between land reforms, agricultural productivity, and poverty.
This is fundamental. Land reforms, abolishing zamindars, securing tenant rights, land ceilings. These were huge administrative tasks. Where the bureaucracy actually implemented them effectively, you saw a real impact.
How does giving someone secure land tenure actually boost productivity?
Simple. If you own the land or have a secure right to it, you're willing to invest in it. You'll dig a well, buy better seeds. That security incentivizes investment, which boosts productivity. And higher productivity means higher income and less rural poverty. The failure of many land ceiling laws was a failure of administration, bad records, collusion.
Okay, broader economic policy now, food security. There was a question about the challenges in implementing the food security bill and the issues it created at the World Trade Organization, the WTO.
The implementation challenges are, well, they're logistical nightmares. You have to accurately identify who gets the benefit. You have to stop the subsidized grains from being stolen or diverted. And you need massive storage and distribution infrastructure. If the administration is weak, the whole thing falls apart.
And the WTO problem. How does our domestic food policy become an international issue?
It's all about subsidies. The WTO has rules about how much a country can subsidize its agriculture in ways that might distort global trade. Other countries argue that India's policy of buying huge amounts of grain at a minimum support price, or MSP, and then distributing it is a massive trade-distorting subsidy.
And it breaches the allowed limits.
They argue it breaches the 10% limit allowed for developing countries. India has its counter-arguments, of course, about food security and outdated calculation methods, but it's a major ongoing policy challenge for our trade negotiators and bureaucrats.
Finally, let's look at liberalization's impact on Indian companies and their ability to compete with MNCs.
You know, the initial impact of the 91 reforms was a huge shock for many Indian firms. They were smaller, used older tech. But the story today is much more nuanced. In sectors where India had an advantage, like IT services or pharmaceuticals, our companies didn't just compete, they became global leaders.
So it's a mixed bag.
A very mixed bag. Companies that were adaptable and invested in technology have thrived and become MNCs themselves. But it shows that policy has to be smart, and the economic bureaucracy needs to be competent enough to create an environment where domestic firms can actually scale up and compete.
So we've really covered a lot of ground today.
We have. We went from the specific constitutional articles for the SPSC, like 315 through 319, which secure their independence. And then we connected that directly to the wider government architecture, like the All India Services and the federal check in Article 312.
And then we layered on top of that the whole rights and judicial structure, the huge expansion of Article 21, the balancing act of reservations in cases like Indra, Sawhney, and those strict limits on suspending rights during an emergency. The big takeaway for you is that knowing the Constitution is just the first step.
The real challenge is understanding how it all works together, how it underpins governance, security, and economic reform, just like we saw in those mains questions.
Before we wrap up, we have one final provocative thought for you to think about on your own.
We noted that the courts have expanded Article 21 to include the right to protection against hazardous industries. Now, Given that the SPSC recruits the very administrators who will go on to issue environmental clearances and enforce industrial laws, should the constitutional requirements for SPSC members themselves specifically mandate expertise in environmental science or public policy analysis?
Wow, that's a heavy question. In other words, does the high standard the court sets for the right to life mean we have a constitutional duty to recruit administrators with the right technical skills to protect that right?
It's something to think about.
A truly complex question. And if this deep dive was useful for your preparation, please do support us.
We humbly ask you to subscribe and, if you're able, to join our paid membership on YouTube. It really ensures we can keep creating this kind of detailed content for you. We're incredibly grateful for your support.
And don't forget to like this video and share a comment. We'd love to hear your thoughts.
And one last reminder on the notes. Free notes with PYQs on our Telegram channel, and the premium notes with Model Main's answers are on the Discord channel for our Legend YouTube members. Do join there.
Thank you, and keep learning.